Previous lessons have spent a little bit of time talking about the ways in which terms can be implied into a contract. We noted, for example, that terms may be implied into a contract in fact, and we noted that there are two major tests that we can look at to make a determination as to whether or not a particular term may be implied by fact. This lesson is going to talk about the ways in which terms may be implied through law. And then what I'm going to do is essentially just do a basic overview of what we've been talking about so far in the previous lessons, and then talk about how we make the shift from terms that have been implied in fact to terms that are implied through law. The last two lessons looked at the two main tests for determining whether or not a contract may be implied in fact. A contractual term may be implied in fact. We noted that these are the business efficacy tests versus the officious bystander test. The business efficacy test refers to this idea of a term being efficacious for the business practice, such that it is almost necessary for that term to be existing in that contract. If that is the case, whereas it is not actually expressly stated in the contract, it will be implied into the contract. The officious bystander test is actually one of my favorites because essentially what the officious bystander test tells us is assuming that somebody is overhearing your conversation where you are negotiating a contract with another individual and they come up to you and say, "Is this term in the contract?" and your response is, "Of course, yes it is," then this implies that that term should exist in the contract, given the fact that it is so obvious that just an overhearing officious bystander may be able to implicate that term in the contract, and so as a result of which it is so obvious that it should therefore be in the contract. So, like I said, previous lessons are talking about the implication of terms by fact, representing situations where it is clear that the parties in the contract, the parties in question to the contract, had implied these terms without expressly stating it or necessarily having them expressed in the contract itself. When it comes to terms which are implied by law, it is often irrelevant whether the parties had in fact originally intended for them to be included in the contract or not. In fact, terms which are implied in law are actually very, very different to those that are implied by fact. The fact of a particular circumstance may give rise to the existence of a contractual term that has been implied, owing to the fact that it is necessary for that term to exist. And it is also necessary on the part of is clearly an intention on the part of the parties for that term to exist in the contract. But when we think about terms that are implied by law, it is often irrelevant, as I've said here, that whether or not the parties had originally intended for them to be included or not. They're often implied into contracts for the purposes of protecting the interests of parties to the contracts. So where it is clear that a term needs to exist for the protected parties to actually have their interests upheld and their interests protected in the contract itself, then it may be implied through law. An illustration of this can be seen in the case of Liverpool City Council versus Irwin from 1976. In this case, we see that terms may be implied into contracts in order to protect the weaker parties to the contracts. So this doesn't necessarily speak to the facts of a particular case, or even necessarily to the intentions of the parties, but it may speak to the views and the relative power dynamics that exist within a contractual arrangement, such that the weaker parties need to have some kind of protection, and so it is implied in law that those terms exist. The case itself involved a council that ran a number of tower blocks, which had alleged to have been deteriorating. And it was argued by the Liverpool City Council that, or at least it was argued that the Liverpool City Council had in fact breached their contractual obligations owing to the implied term that the flats had such repairs were necessary for the enjoyment of that property. So by reference to the fact that they had owned and ran this tower block, the Liverpool City Council were therefore in breach of their obligations for the fact that they had a duty implied into the contracts to make necessary repairs for the enjoyment of the property. At the level of the Court of Appeal, what was introduced was something of a reasonableness test, a reasonable standard, which is of course an objective standard test, for suggesting how terms may be implied through law into a contract. And they suggested that the terms may be implied on the basis of this test. This was something which was ultimately rejected by the House of Lords, however. The terms were not implied in fact, but rather they were implied in law. It was implied not on the basis of the facts and the factual implications of the particular circumstances, and a fact-based implications test therefore was not necessary for the implication of a term in this contract. In the same way that we looked at previously, it wasn't necessarily efficacious for business, or it didn't necessarily fit the officious bystander test. Rather, the terms were implied in law on the basis that it would be desirable for an obligation to be placed on the owner of such a property to ensure that the property itself maintained the basic standards of living. And so as a result of which, it was irrelevant as to the intention of the parties, whether or not they intended for this contractual term to exist in the contract itself, or any other kind of test that may be introduced on the basis of facts, like a reasonable person test, a reasonable person or a reasonableness test for the enjoyment of the property. Instead, it was an obligation in law on the basis of the fact that there should be this obligation for the owners of such property to ensure that the maintenance of this property were up to the scratch of the basic minimum standards of living.